I actually, her, I have talked about it, but she just went.
Thank you.
Did it look like it?
I know you were looking for Kleenex.
Good morning, everyone.
Sunglasses.
She said, I'm in, but I don't hear anything.
Who said that?
Nora's telling us real
Okay.
time.
Okay,
Now we see you.
if anybody on Zoom cannot hear, well, they're not gonna hear me, right? I was gonna say, raise your hand.
She hears it now.
Hi, Blair. My name is Maria Barber, for anybody who doesn't know me. I work for the Family Navigation Network at UNR with the Nevada Center for Excellence in Disabilities. And I am living the same thing you all are living. I have a 17-year-old with cerebral palsy, so we're in this transition stage. So when this came about, Family Navigation Network had already realized the importance in our community of needing this. So they are funding it and sponsoring it, and I am running it. So if anybody has any input, and if you hated this and you have some ideas, please reach out. We'd love to collaborate with the community. And the Family Navigation Network is a family-to-family healthcare connector. So if you know anybody that needs help navigating the system, please have them, they can go on the website and fill out an intake form, and then a navigator will get in touch with them and be able to help them with whatever they need. So today our topic, and we have topics all year long, by the way. So we'll show you at the end our next series of topics. Can you want to hear me now? Would you text her?
She said she could hear now.
Okay. And I will email that out as well after the session with a follow-up email. So today is our Transitioning Together series of supportive decision-making and guardianship, which are some pretty complicated topics to really wrap our heads around. So Homa, Sayyar Woodrum is here today, and she will introduce herself and explain her background, and you're gonna love this. Welcome, Homa.
Hey, Maria, this is Kamala.
Yeah.
Yep, I just want to let you know I'm on the chat, and I'll be monitoring the chat.
Thank you.
Awesome.
Yes, Homa. So Kamala will be like stopping and saying, we have a question here.
Absolutely, we'll pause.
And then, are we recording? Are we recording?
We're recording, we need to give guidance around the search translation first before she gets started.
Would you?
Julia.
Oh,
Julia will do it.
Okay, we have interpretation mode, so we'll have a disclosure about that. So go ahead, Julie.
Okay, we're not hearing you.
She was probably on the Spanish channel.
oh.
Julia, we're not hearing you. No. No, no.
She's on the English channel right now. Are we on?
Yes, don't be on the, go into the original audio room, not the English room. That's a same. That we got it from live, because that's what it's happening.
Well, I heard, that's why I think it's 5.
Julia, we're definitely not hearing you yet. What's so loud?
There might be a crazy. She's here, but she might. Try to get it. Yeah.
Hey, Marie, and we have somebody on Zoom that's having technical problems and they can't hear anything. It's Kate.
Oh, Lauren said turn off interpreter mode so we can give the instructions.
Right?
Yeah.
Okay. Uno momento, por favor. Okay.
Everybody else's are breaking, like mine is attached to anything, it's not broken.
Okay, Julia, I amended interpretation. If you want to try to speak now, I've ended
I don't know,
interpretation.
she has that.
Folks, can I please fast it while we get this technical? Gabby?
Can you hear me now? ¿Sí me escuchan?
We appreciate your patience while we get this set up. Julia, you
Gracias
want
por-
to try to speak again?
Gracias por su paciencia. Ahorita lo que sucedió es que María Barber se presentó. María Barber forma parte de la organización Family Navigation Network, cual es una red que conecta a las familias a acceder a todos los servicios médicos. Ella también tiene un niño que tiene parálisis cerebral de 17 años, entonces ella sabe lo que debe uno hacer y quiere estar aquí para ayudar. Es parte también de la universidad y es la organización de nuevo Family Navigation Network. Ya van a dar las instrucciones. They're going to provide the instructions, correct? And I will interpret those to Spanish.
That was perfect. Can you read them in English now so that everyone knows what you shared in Spanish?
So I interpreted what you, Maria, what you just said at the beginning into Spanish.
Okay, I'm gonna go ahead and turn on interpretation then. Give me just a moment to get that set up.
Ahora lo,
We will begin the presentation.
okay, ahora lo que vamos a hacer es,
I can't read it.
They put it in the chat, they put the instructions. If you're on English, make sure you select in English when it enters interpretation mode. If you want to hear
okay,
Spanish.
cuando van a ver una pantalla que va a decir modo de intérprete.
On English, join in the English room.
Ok, van ahorita a unirse al cuarto de inglés si se hablan inglés y de español si hablan español, se va a abrir ahorita.
Great. So if you have any problems, once I initiate the interpretation, please use the chat and we'll try to troubleshoot from there.
Si
Thank
tiene
you.
problemas, por favor, dejen el chat y vamos a partir de ahí. Gracias. Entonces seleccionen español, el idioma, para entrar al chat.
Good, Marcia?
Just a second. This has a lag. That go to English? Yes, it's on English. All right, I think we're set to go. Thank you for your time, everyone. This is the first time we've done interpretation and there's just a lot of technology to work through. Appreciate your patience.
We're on English.
Yes.
All right, cool. Thank you for everybody's patience with the technical. Okay, so like I mentioned, my name is Homa Woodrum. I am an attorney in the state of Nevada. In private practice, I was a guardianship attorney in Las Vegas. And was doing years and years of that, representing guardians, protected persons, the Public Guardian's Office. And it started to feel like it was the same story over and over again, where we were intervening after something bad had happened, right? And I wanted to do something more preventative. So my husband showed me a job posting in Carson City, and it was for a disability rights attorney. And he's like, this is what you should be doing. So I moved up here. I was over at Aging and Disability Services Division for a couple of years, switched over to the Attorney General's office where I represented Medicaid, and got some experience there. And then most recently, I'm now in-house general counsel for a state agency, but the disability rights world has never left me. And so part of what I'm able to talk about today as far as guardianship and the supported decision-making is because I've also had that perspective shift. I've also gone on the journey of being in this mindset of guardianship protects people, everyone should get a guardianship, this is great, we're gonna wrap everyone in bubble wrap and it's gonna keep them safe, to having my learning experience and my perspective change about individual rights and just really understand sort of the person-centered disability movement. So I will say it's a safe space where, what you believe today may change tomorrow, it may change in a couple years, and that's good, right? We should all grow and change. I mean, we're moving from, we moved from a concept of institutionalization, right, to community based living. So what's next, right? What sea change is next? So just give yourself some patience as maybe the first time you hear about something, you might be like, this isn't familiar to me, this makes me anxious, that's okay. And the more you hear about it, or the more you learn about it, or hear about success stories, you may change your mind a little bit.
This is Kamala.
Yeah.
Excuse me. The interpreter is saying, please remember to speak slowly so they can interpret.
Thank you, that's the problem I have, I apologize, I will go slower.
This is it.
Yes. Click the new share so it'll share the slide decks. It's still showing the folder. Okay. Marcia, if you go to the top and select new share, because it's still showing the folder.
Where does it say?
So if you go up, there's a green arrow, new share.
Right there.
Left, one more, there, click that one. And now select this one. Whichever one you want, the screen, you can just do the screen, that's fine, yeah. Thank you for that. All right, so next slide. So as I was mentioning, remember to take care of yourself, check in with yourself. If you're feeling anxious or nervous, that's normal. You're worried about transition. Transition is difficult. It can be something new, it can be something unexpected. You've learned how to navigate the challenges of your world today, and you may not like the feeling of starting over a little bit. And it's okay to ask for help as far as support from other people who have gone through this, other people who are in the same situation. So the theme for supported decision making is that it's okay to ask for help. It's also okay for us to ask for help. And it is also okay if you feel that someone or something is pushing you faster than you might be ready to go. It's okay to say no, or let's reframe our options. So next slide, please. So part of checking in with ourselves is asking ourselves how we feel about certain topics before we get started. So you might ask yourself, how do I feel about guardianship? How do I feel about supportive decision making? And if all of that is new to you, you may not have an opinion about that, but you might ask yourself, how do I feel about my loved one turning 18? How does that make me feel? And if it makes me feel scared or anxious, that's okay. And it's good to check in with that because we may have had difficult experiences fighting for services or wrangling school administration to try to get accommodations. And suddenly the world says to you, here's a magic wand, your loved one is 18, now they get to go forth into the world. And you might say, we're not ready for that. Or what does that look like? So you also want to think about how others feel. So the world may be saying, go get a guardianship or go use the courts because it might be easier for them to deal with the situation, to just talk to you, not talk to your loved one. Think about what might be good about the journey that you're on, that more independence or using other tools might mean that it's not all on your shoulders, right? That you could plan for a future where a network of supports is there for your loved one and it's not all just you or your immediate family. Or you can ask yourself, what don't you like about this transition or what might happen next? Because there may be a tool to address just that piece of it without, broadly using a particular court tool or document. And then just thinking about what might the unintended consequences be. So consider what you've already learned in your own journey, both the negative and the positive experiences, and consider why others might nudge you into a more or less restrictive option for transitioning. And also consider cultural and community barriers, because in some cultures, it's a point of pride to continue supporting and being there for your loved one. And that someone might have family telling them, well, if you don't get guardianship, are you sort of abandoning your loved one to the world? And that's a challenge in guardianship court we would hear about a lot, where people would say, I don't want to look like I'm not doing the next right thing. And so that culture or that community around our options, those people may not know that you're actually doing just that. So it's okay to understand that there's pressures on people about the subject. Next slide. So the words that we use help define issues. So this slide is part of checking in with ourselves, where there may be imagery or messaging about disabilities that mean one thing to us, but mean something different to somebody else. So some of these graphics on the slide are common disability-related symbols. For example, the infinity symbol for neurodivergent, or this disability rights or civil rights, that's the slogan for the anniversary of the Americans with Disabilities Act. Or we may see iconography of somebody showing a picture of a wheelchair, right? And that's supposed to evoke disabilities. And in the disability movement, there can be sort of factions, right? Different people may not be a partner in what you're trying to do. For example, if somebody's focused on physical disabilities, that may not be inclusive of any challenges you have for intellectual disabilities. I went to a training once and there was a presentation from someone who worked with disabled veterans. And one thing that they had experienced was that those disabled veterans didn't see themselves as an ally of other disabled communities because they didn't think they were like them, and that can be, it's a shame if people start drawing those lines, but if they don't identify with that community, they may not be supportive of the kinds of things that other disability rights groups are doing. And then what message does it send if people feel left out of a movement or included by a movement? One thing I learned through my own journey is the world of person-centered versus person-first language. So I was taught at one point, well, always don't say disabled person, say person with disabilities. And I said, okay, I'm gonna go out in the world and do that. And then I learned, and then you learn, wait a minute, maybe I should ask that person how they would like to be referred to, right? So sometimes in deaf communities, they want to be referred to as capital D deaf, right? Not a person with deafness. I don't get to decide that. That person is driving that situation. So that's another check-in we do. What language am I using in this space? It's not to police anybody's language, but the fact that I stop myself is a good step, right? Let's check in with that person and see how they identify and what matters to them. And then, same with allies, parents, and supporters. Some movements, especially in kind of the age of the internet, sort of start to exclude supporters, right? So you might wander into an autism community online that has, a very negative opinion of people who surround somebody who has autism. And maybe that's a safe space for people to vent, right? And or that sort of thing. So it's something to consider. So in guardianship, in Nevada, we used to have the word ward, W-A-R-D, in statute. And everyone said, that's become a bad word. We need to change it. But when we kind of chase that, soon the new word will become the word that people have a negative association with, and it'll keep changing, and that's not a bad thing. Now the term is protected person. A protected person implies somebody who needs protection, not somebody who needs support. But when they were working on the law change, I was against the term protected person. I thought it sort of built in this idea of someone who needed that bubble around them. Why don't we, instead of saying Ward or protected person, say Susie or Jimmy? They have a name. That's not hard, right? But lawyers love to just come up with these categories, put people in boxes. So be aware of that the lawyers in the world who you might talk to have their own perspective about what makes it easy for them to generate a court paperwork for you where they don't have to use your name. They just click print. So just be mindful of those words. Next slide. So the thought I want with this slide, it shows a scale of justice and it talks about individual rights and personal autonomy. And it's asking us to think about the words that we use to describe an issue. So on one side of the scale, it asks, is guardianship helping people with disabilities access services? That's a message we've all heard, right? I'm going to go get a court paperwork, and now the doctor will let me be in the room, and the school will let me be in the room, and someone will agree with what I think is best and safest because I have this paperwork. Or someone might say guardianship intrudes on the private lives of people with disabilities to control and isolate. Both of those are extremes. And both of them maybe have a bit of truth, but it's not, you can see how it's not fair to just lump it in with one or the other. Guardianship can be life-saving, right? It can help somebody get all the help and tools they need to have a happy, productive life. But it is true, part of the reason I left Las Vegas to come up to Northern Nevada was because I litigated the April Parks guardianship exploitation cases. So I had 47 cases where a private professional guardian had come in, take control of people's lives and money, and use them for her own profit. She billed about 100 hours a day. So each case, she would bill a little bit here, a little bit there. And when we got all her records and tallied them up, the court was happily approving someone who claimed that they were providing services. She would go to secondhand stores or dollar stores and buy small trinkets and then charge people her $300 an hour rate to visit them and give them presents. I mean, this is the extreme. And a lot of our guardianship law changes that have made it harder for families to access guardianship are a reaction to this bad actor, which is a shame because guardianship should be accessible to families who really need it. You shouldn't be treated like criminal coming in to ask for access to a bank account. But unfortunately, the safety's wrong in those cases. So if you are researching guardianship, you might find really extreme opinions. And remember, check in. Why might someone have that extreme opinion? It's because they've had a negative experience. But your experience is going to be your own experience. So just be aware that guardianship has become kind of a bad word. Britney Spears, you may have heard of her in the news. She had mental health concerns. Her family used guardianship to take advantage of her. She's a pop singer. And so in her story in Nevada, I always said her family wouldn't have been able to get a guardianship because the help that she needed was not suited to guardianship. But again, every state's different. So just check in with yourself. So next slide, please. So supported decision-making, which I'm going to go into more detail about, we have the same community difference in how we describe it. So on one hand of the scale is supported decision-making empowering individuals with disabilities to make decisions, or is it a way for people with disabilities to be influenced without oversight? I have heard both sides of this, and just like the guardianship discussion, somewhere in the middle is the truth for you, right? It can be an empowering thing where it's the right thing for your family, and if it's not going to address all the concerns of safety that you have, let's use that as a tool along with other tools. No one tool is I'm picking it and I have to be with it forever. So just keep that in mind as we talk, when I talk about your options in this space. I'm not saying any one way is the right way. I'm not saying anything is bad. just check in with yourself about how it makes you feel. Next slide, please. So your perspective matters. What you bring to this matters. So on this slide, there's a picture of a mirror, and it always says objects in mirror are closer than they appear. So from where you're sitting, something may feel more anxiety inducing than it feels to someone on the outside. So the things you believe are shaped by your experiences, and learning your perspective and other people's perspectives will help you work with others, right? The doctor in the doctor's office who doesn't want to let your loved one decide something medical, they're coming at it from a liability perspective. They're scared of getting sued. It's not about you, right? It feels like it's about you. It feels like you're being challenged and that you don't have anywhere to go. Be prepared to disagree with others, right? It's okay to say, no, that's not correct. And it's hard when those people are sitting in positions of power. And when I talk about self-care, you don't have to sometimes be the one to do that education. If you don't feel up to it, call in help of others, right? Contact your supports. For example, the team with FNN, or maybe there's handouts or tools, and I'll share them at the end, where you could hand it to someone and say, here's some guidance about this subject. Oh, go ahead. Is there someone-
Excuse me, this is Kamala. The interpreter's asking you to slow down again.
Yes, thank you. I will.
You're welcome.
I apologize. So how we talk to each other has changed in the age of social media. And we want to consider whether people are better or worse at having disagreements nowadays. And I would say probably worse, because people retreat into themselves and they will cling to a position and not be open to learning something new. And people seek out those who agree with them. So you can find a message board or a Facebook group for any topic or any group. Sometimes it's nice to talk to people who are going through what you're going through and go, yes, this is scary. Yes, this is something I'm worried about. But sometimes it's not good to be in only those spaces. We should also be in spaces where someone says, I'm you 5 years in the future. Look how great this can be. So I do that sometimes, right, when I'm reading the news, where it's all doom and gloom. And I say to myself, I need to go find another source so that I can get myself out of this headspace. And people can be quick to judge instead of listening and learn. Disagreement is okay. What works for your family may not work for somebody else. And you might just be sharing information and somebody might not be ready to hear it. So next slide, please. So in the disability world, there has been a transition in society's model, the culture of society. Disability used to be viewed through the charity model, right? Where we are doing things that are kind for people and because they are helpless. We've had this belief of their helplessness. And so then we moved into the medical model to say this person has a medical need, so as a society. And now, which is I think a great place to be, is the social model. What's wrong with society that's making it hard to adapt, right? If you were in a farm community where your loved one walks out the front door and they're hanging out in the fields with some cows, that's not the same safety concern as someone who walks out your front door and is in traffic, right? That's society that changed. That, or a community where if you were wandering around downtown, your neighbors knew who you were and would say, hey, do you want to call your mom? Can I call your dad? Can I help you get home? We are so depersonalized that the world is harder for us to access than it used to be. And yet we say to a person with disabilities, that's on you, right? You can't access these services, so it must be that you need help instead of us fixing it for everybody. And that's one of the arguments in the disability accessibility world, right? Why don't we have ramps instead of stairs? Because the ramps don't only help the person who has mobility issues. What about the mom with the baby in the stroller? One of my favorite things is so much of the tools on our phone that remind me where to go and what to do, that read things to me, that translate things for me. A lot of those are tools that came from the blind community, and it benefits everyone. So the social model says, let's make society more accessible instead of less accessible. And we need to respect what's called the dignity of risk that we learn sometimes through our bad choices. And society sometimes isn't allowing people with disabilities to have those quote unquote bad choices in a safe environment. Because if you wrap someone in the bubble and they don't get to date, or they don't get to have a movie night with their friends without you there, then they aren't getting to learn, hey, if I don't feel comfortable at my friend's house, what do? I can call my mom, or I can call my friend. Those are safety skills, but we learn them by being in uncomfortable situations. So that's kind of the social model. And we always want to finish this phrase, the capacity to do what? You don't just get to say, Susie lacks capacity. What does that even mean? Maybe Susie can't do her taxes on her. Or maybe Susie needs help balancing her checkbook, but she can choose her friends and who she trusts or what she wants for dinner. So capacity is not, it's not a sentence that ends there. The capacity to do what? And that's where sometimes if we're talking about the capacity to do something super complex, maybe guardianship is where we need help. But if it's the capacity to make a decision, maybe supported decision-making is what will help bridge the gap for that. So it's something to consider. So next slide, please. So the way that I explain rights is the way that we were taught it in law school. And it's, to me, it really helps me understand more complicated legal concepts. And it's called the bundle of sticks. So if you imagine that every right you have is not just one right, it's a bundle of them and you're holding them. So if, for example, if I have a prescription medication, right, the pharmacist gives it to me, my name is on it, I have the right to use it according to the label. I have the right to keep it in my home. I don't have the right to sell it, right? I don't have the right to give it to somebody else. So in our lives right now, there are things that we actually don't have what we think, or we think of them as our full rights. We don't. We can't just go and walk into someone else's house and say, this is my house now, right? Those rights are things that we've created under the law. So we can delegate authority for our sticks. We can share them. So for example, if, and I'll explain this later too, if I have someone who has power of attorney over me, right, who they can make medical decisions for me, a lot of people culturally believe I have handed the stick of decision-making to them. Actually not true. I'm sharing them. They can't make decisions that I don't want. They need to be making them consistent with my wishes. In supported decision-making, we're not giving away the stick of deciding what to do for fun or who our friends are. We're actually asking someone to help us make our own decisions. And in guardianship, the court is saying that someone can take that right away, the right to vote, the right to possess a firearm. So in all of this continuum, it's a matter of, are we sharing those rights? Are we delegating them? So it helps me conceptualize that it's not a zero sum, it's not all or nothing. Because even if you have a guardianship, you keep certain rights, and we'll cover those too. So it helps me think about it. Next slide, please. So this is a wordy slide, and I will go slow. Sometimes fear is helpful, but sometimes fear keeps us from achieving our goals. So on one side of the slide, they're kind of two sides of the same coin. So I'm going to go left to right. If you have always lived at home, you might be scared of moving to a new place. The flip side of that is if you've always taken care of someone, you may be scared that they'll get hurt. These are all valid fears. If you've always gone to school and are looking at jobs, you may be scared of doing something. Everyone's been scared of starting a new job, being a new kid. But if someone you care about is scared, you may want to protect them. You may want to make it better. If you've always had a guardian, you might be scared to look at other options. So there are a lot of people who've been in guardianship for many years and don't want supported decision. They don't want the other options because they're being asked to change, and that's okay, right? That's part of education, that's part of outreach. And if you've always been a guardian, you might be worried that bad things will happen without her. Finally, if you disagree with a friend, you might be scared to challenge them because you might be scared to lose the friendship. And if you love someone, you would actually be sad if you found out that they were scared to talk to you, tell you how they were felt. Was there a question? Should I pause? Okay, just making sure. So when I talk about checking in, that's what I mean, is that these fears can be valid, but they we can work on. So next slide, please. So the law produces the capacity is the ability to make decisions, to make and communicate decisions. That means once you turn 18, the law says, cool, you can sign contracts, you can vote, there are things you can do. But that's scary to us when we're thinking about transition. It's like a switch gets flipped, maybe we weren't ready, we don't feel ready for it. If someone tells you or your loved one that you can't make a decision, so they go to the doctor's office and the doctor says, I'm gonna need someone else in the room to come in with paperwork. This happens a lot, right? Then they might tell you, you need to come back with a court order, and that's when people head to guardianship court. And research calls this school to guardianship pipeline, because the people in these schools are sharing information they've always shared. And maybe it was the right answer when we didn't have other options, but now it's not really the right answer. And that's part of the outreach and education that we do. And people might still try to convince you or someone you care about of something that isn't true because of their own fears. Like if a doctor is scared, you may sue them for not doing a good job. They may not want you to make your own decisions because they don't want to get in trouble. This happens a lot with dental care, where dentists will say, I don't feel comfortable doing this procedure. Even if they have a patient sitting right there who says, I'm good with it. Let me have the procedure. They'll say, come back with a guardianship order because of their lack of education, not yours, right? So that's something to consider. And that was why we brought the Supported Decision-Making Act. Next slide. So the Supported Decision-Making Act passed in 2019. And it said a couple things. One, people can't use it against you if you need help making decisions. And the supported
This is Kamala. Sorry, the interpreter is just asking to slow down.
All right, I will keep your.
Sorry.
I know, I appreciate it. I get in the role. So it happened because of self-advocates and their families and their friends. So the picture on the slide was from the bill signing ceremony. There's Governor Sisolak. There are folks you might recognize. Travis is over there, and he testified on the bill. We had Diana's son, yes, Marcia's son is in that picture too. It was a very cool day. And one thing to remember is that we didn't actually need a law. The law should have let people make decisions and have supports without, something specific on the books. Judge Doherty from the 2nd Judicial District had piloted a major study that said, we can do it right now. We don't need a law to do supported decision-making. Because remember, the law presumes capacity. You don't need someone to tell you it's okay to have help. But our challenge was the doctors and the schools and the people didn't recognize that. And so we brought the act to say, you won't be sued if you rely on someone who has support. That's kind of the magic words they need. But for the rest of the folks, they were already doing it. Mary Bryant was already doing supported decision-making with her daughter. There was also already a law on the books called the Power of Attorney for Intellectual Disabilities that advocates have pushed for. The problem with the power of attorney is doctors went into the mindset of substituted decision-making. So handing the stick away. So we needed it to be called something different. We needed it to be in a different chapter. That's chapter 162C. And it is called the Supported Decision Making Act. So that was pretty exciting that that passed, and it was unanimous. So what is supported decision making? I've talked about it a lot. It is a way to get help making choices and have those choices recognized. And all of us do this every day. When we want to choose where we live, we might ask a friend if they like their neighborhood. When we choose what we want to study in school, we might shadow someone whose job we like. Where we work, maybe we do research or talk to friends about if they like where they work. Who you spend time with, maybe we ask advice. Maybe I have a new friend and I introduce them to my other friends. And then afterwards I say, did you like my new friend? And that might give me some support or help understanding if that's a good choice. If you want to go to the doctor, studies have shown going to the doctor alone is not a good idea for any of us. We should have someone else in the room to help listen, because we might be really upset about what we've heard and we didn't hear everything. So if I were to bring my husband with me to the doctor, can you imagine if the doctor said, well, I see that you need help, so I'm not going to help you unless you come back with a court order that says your husband can help you. But that's exactly what people are doing every day to people with disabilities. They are discriminating against them, whereas if you present as if you are neurotypical, they let you have your son or your daughter or your friend in the room. So that's the cultural problem that we're trying to fix. If you want to go on a date, this is a big one where, have you ever had a friend who starts going out with someone and you're like, don't really like them, but you don't tell your friend until they ask you. And then when they break up, you go, I never liked him. That's normal. But when someone has a disability and they're dating, maybe they get treated differently. And instead of support, they're told, oh, you don't know how to be safe. You don't know how to make these choices. And that's not great messaging to have. What and when you eat. I tell this story a lot, and it's true. I like to get cash at the grocery store so that when I go to Burger King and buy a chocolate pie instead of eating lunch, my husband doesn't know. My husband is not in control of my life. He's not going to shame me, but it's none of his business, right? It's none of his business what I eat for lunch. And if you want to eat dessert first, that's a choice. Is it the best choice? No. If we all had a guardian in our lives, they would tell us to eat healthy, right? And, you know, it makes us laugh because it's true. But if I did need support on making good food choices, wouldn't it be nice to ask for help and not have that person swoop in and say, well, clearly I'm going to make every meal for you because you can't make a choice, you know? And it's interesting, I'll mention this, a friend of mine, her son has Down syndrome, and they've started doing those meal kits, those HelloFresh, and he has felt so empowered to follow those instructions and make beautiful meals, and they share them on Instagram. And how cool is that, that there are these things that can make even cooking and enjoying food more accessible for people and make it fun. And then how you spend and save your money and anything else. So we use supported decision making. All of us, every day. That happens when I call and ask my mom for advice and then don't take it, right? That's okay too. So next slide. The kinds of support that we can, these are just examples. Marcia, can you scroll a little so maybe the text?
I can't, I'm sorry.
Okay, I'll read it and you have materials in your slides too. So plain language information. People do this when they hire a lawyer, right? They hire someone. You know, we're just gonna see if we can make it full screen.
Yeah, it's a good break.
Is that tweet slides, that might be a good space right now, it's great. Question.
Oh, yeah,
It
process.
doesn't have to be questions, but just give them a second to catch up before you go to.
Okay, I will do. Great. All right. So plain language information, when a client, I do contract negotiation. So a client will hand me a stack of paper and say, what does this say? Well, you're buying this and they're selling you that, but it's pages and pages and pages. So again, support for plain language information is something we all need, we all use. And guess what? We should all speak in plain language. Like, let's stop, that's that social model. Let's stop being more complicated than we need to, so that we can be inclusive of everybody's reading level. Research, so help learning about something. Extra time, so maybe someone needs a little bit more time to process information. Reminders, this is where our phones are amazing, right? They can give us that little leave the house now, a reminder. Having a supporter at meetings is, when I do my daughter's 504 meetings, I speak in public, I've litigated cases, my voice shakes because it's about my family and my life and someone I care about. So having someone else with me to help, make me feel better is support, and I use it. A reminder of your values. This happened to me a little while ago where I was really upset about something, and I told my husband, and I said, I think I need to switch jobs. And a couple of weeks later, I said, I think I can stick it out. And he reminded me, no, you're still upset, right? You're just convincing yourself that you're okay with this. And reminding someone of their own values, or if a friend said, I'm gonna go in and ask for that raise. And then they come back and say, well, they offered me coffee on Fridays. Then that friend can say, no, you went in there to ask for the raise, in a supportive way, right? Help communicating your choices. If, talking to people gives you anxiety and that person can restate your wishes, that's an awesome form of support. We also have information in pictures or explain to us, that's helpful. Advice, that's a common support. The graphic with the eyes is visuals and trials, maybe shadowing something for someone helps. The checklist shows help thinking about pros and cons. The next one is talking to experts. After that, it's classes, so you could take a class and learn something more. And the computer is technological support. So you can, when a blind person uses an app where they show someone on the other end what's on the store shelf, and they can tell them which one is the 2% milk and which was the vitamin D milk, that's support. They're using support in that moment. So these are types of support. And all supported decision-making says in Nevada is that when you get this help and use this help, it can't be used against you to argue that you're not able to make your own decisions. Next slide, please. So there are two people in a supported decision-making relationship. The decider, which sounds like a transformer. The decider chooses who they want to support them. It should be someone they trust. That person can help them find information or communicate their decision, but those people and others must recognize the choice of the decider. So they're in the driver's seat, right? They're deciding where to go. Their supporter may be sitting in the passenger seat with the map and saying, turn left at the next light. But the person in the passenger seat doesn't decide whether or not to make that turn. They can only help you. Next slide, please.
I have a question.
Yes.
Just because some of us learned about microboards back in the day, and I wonder if they're pretty much the same, I assume. But then when I see that the decider picks one, is just one person?
I'll restate your question for the group just in case the mic didn't pick it up. There is a concept of micro boards where you have a group of supporters. And the question was whether you only have one supporter and one decider. You can have as many supporters as you want. You can have as many supported decision-making agreements as you want. Some people split it up as, here's my team who helps me with healthcare, and maybe it's a different team than the people who help me with my finances. So it's a choose your own adventure. So a micro board would be your group of people, and maybe they all work together to support you. That's totally fine. This is like the base model. right? What you need for a supported decision-making agreement is at least one supporter, and you have the decider. You can have as many as you like in whatever configuration you want.
Okay, I just didn't understand if the language had been changed and updated to supported decision-making, and it meant the same thing as microboard.
Microboards and supported decision-making are the same thing. The piece with our law is that the decision of the decider, with the help of their supporters, must be recognized as if it was any of our decision on our own. They can't use it against you. So someone, I don't know if you're familiar with Santa Perez. She's written an amazing book about her experiences with her disabilities. When she was pregnant with her son, she put together a microboard to help her navigate her pregnancy and what she might need. So she was doing that long before this law passed. So it's absolutely still on the table. This is just a way to appease the doctors and risk managers and bean counters who for some reason wouldn't accept what we all already accept. That's a good question. So we have the decider and we can have one or more supporters, but the supporter has to do only what they're asked. They can't invade the decider's privacy if they don't have permission. So the example for that is if I need my supporters' help to schedule my doctor's appointment, but I want to be there on my own, then they have to respect it. They can't call the doctor the next day and say, hey, what did she hear from you when she was in the appointment? If the supported decision-making agreement is just about help making appointments and getting there on time, it's not about what happened or what procedures I might be getting. I haven't seen an agreement that's that restrictive, but I use that as the example to mean there are guardrails, right? What the decider thinks they would like as their support. And so if they say, help with all my healthcare, that's pretty broad, but you should keep checking in with them and see, did you want me to come with you today? Did you not? Do you want to try it by yourself? Do you want me to sit in the lobby? Those, you don't have to put all that detail in the agreement if that's not how you operate. But if they want to start having those boundaries, that's okay too, because that might mean that they're trying to be more independent on some of the things.
Can you have those boundaries? I mean, some of us have kids, like for instance, my son just had 4 visits people. And if it was up to him, if he would have known how much they hurt afterwards, he'd say, heck no, I don't want my teeth pulled. He had to have people, they were impacted, they would cause problems in the future. So
The question is, how do you support someone who may not make decisions in their best interests? In a situation where your son wants your support for medical decisions, and you know that now that he knows how much it hurt, he may never consent to another procedure, the discussion of what to use the supported decision-making agreement for might change. And so what you could do is have the conversation of, does he want to have that decision, or maybe he needs your help overcoming that fear? So what we do in that situation is the supported decision-making agreement says, I'd like help and support doing a power of attorney for healthcare. And then you can supplement it with that power of attorney where maybe you give that consent for that procedure. But it is challenging because you could have someone who says, no, I don't want to take care of my teeth. I don't want to, go to the dentist. And in that situation, if somebody is, the law would say that if someone cannot make or communicate decisions in their best interests, then you might want to start talking about whether parts of their decision-making are suited for guardianship, where if a doctor were to say, look, your son is empowered and can use supports, but he's just not going to be able to overcome the barrier of making those major decisions, then you might end up with a guardianship for the narrow situation.
that's different than having power of attorney.
Yes, the power of attorney is different from a guardianship because in a guardianship, substituted decision-making, where you can tell the doctor, go ahead and do the procedure, even if your son is sitting there saying, I don't necessarily want that procedure. In a power of attorney, if he's sitting there saying, I don't want the procedure, the doctor can't, has sort of those competing wishes, and there's a challenge there. But a support might be, would he feel better with more pain management afterwards, for example? Maybe that's a way to approach support. I remember how much that hurt. Maybe we can ask the doctor for more medicine this time. So there could be a way you navigate it through support, but it's, like I said, could be a mix. We have a lot of cases that continue in guardianship where someone has a complex medical condition that they really have a hard time managing. Seizure management is a big one, where they have a supported decision-making agreement for everything else in their life except medical, because they just aren't able to manage.
So you can have a medical guardianship.
You can have a medical guardianship, you can have a limited guardianship. Yes, there's a question.
This is Kamala. I just wanted to give some personal experience with that. My daughter is 22 and we have a supported decision-making agreement with the power of attorneys. And she, for 2 or 3 years, was kind of going downhill, and she kind of let phobias take over and didn't want to address it. And I just tried to be patient and just every once in a while talk to her about how I was sad about how her quality of life wasn't very good. And she finally got to the point where she agreed wholeheartedly and has decided to start taking care of herself and going to doctor's appointments and that kind of thing. So I get what the person was asking about personally. So, but I just tried to be patient with her, and she finally came around.
Well, I had a problem when we went to check in because the nurse checking us in said, "Are you the guardian?" And I said, "No, I'm we do support decision making." She just was like baffled as to what to do. She says, "Well, there's a box here that says guardianship or not guardianship. So you either are able to go in the room with them and make decisions, or you have to go. And there's no way to make decisions or, understand the doctor saying, take 2 pills twice a day for the next 10 days and use gauze and don't flush, that sort of." So we sat there and went back and forth. I'm like, "I'm not the guardian." She's, "Well, you can't go in." But I'm the support decision making. So I finally just lied and said, "Okay, I'm the guardian." And she said, "Okay." And I went in. And I even had the power of attorney. But it was like, she finally was like, "Oh, thank goodness, she admitted she's the guardian." What do you do in those situations? Because could I get in trouble? Because I don't have guardianship. It's here too.
You were lowercase g guardian, right?
It'll be okay.
But the challenge that you're describing of you're in a tense moment, you're checking in for a procedure and somebody pulls up that big stop sign. In the materials, we have a link. I helped the Governor's Council on Developmental Disabilities draft info sheets for different audiences. One of them is a sheet you could print out and show a doctor, and it's addressed to the healthcare professional, and it says, "This is the law. You need to listen to this," because that's a huge challenge, and you're not emotionally in the stage where you feel like, let's have an educational moment.
Well, I kind of was trying to educate her, but she's like, "Okay, that still doesn't answer. I have a box that says guardian and a box that says no guardian. So which is it?" And
Could you get in trouble for saying you knew what you intended when you said that? I mean, I know that's a lawyer answer, but is it defensible? I defend it. Because what you were offering was legal, which was a supportive decision making.
they just didn't have a box for it.
Yeah. And there was another question.
So my son's 20 and kind of impacting, so we're moving down the road of supported decision making. I can see him legitimately, as we've been through this a couple of areas, saying, "I don't want to be the decider with this particular thing or that." And I don't know if that's how do you?
Yes, your
do
son
that?
could say, "I want to hand that decision
Yeah.
over." A power of attorney for healthcare where he's not gonna be in the room disagreeing with it is a great way to do that. And, slow down.
And if one person can speak at a time.
Sorry, the question, I'll repeat the question. The question was, if you have a loved one who's happy to hand over the decision making, then you wouldn't use supported decision making for those choices. You could use a power of attorney where they sign the intellectual disability power of attorney form, which is in plain English. And it lets them say that they want you to make those medical decisions for them.
It's gonna get me started writing.
Thank you. So there are options there. The only caveat about a power of attorney is it works when you are. Her decider has given you that permission and wants you to keep that permission. If they're going to be in the room saying, no, 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 I don't want this, after signing the power of attorney, it isn't going to help you because the doctor is gonna throw back their hands and say, I don't wanna have to decide who wins in this discussion, but it's great when he's decided that he wants you to just make the decisions and manage it, and you can do that.
And that could follow up. Let's say as we feels more comfortable and shift back and forth as is appropriate.
So the question was, as he gets older, can you shift back and forth as appropriate? You can verbally terminate a power of attorney, so he wouldn't even have to do anything special. He would just tell you, I don't want you to do that anymore. You could do a new one that has narrower authority, so there are a lot of options. I personally have a power of a healthcare attorney for where my husband can make any medical decisions right now as we stand here, because I didn't want him to have to go get a doctor's note to help him if something happened. But I also trust him not to use it to go say, hey, I want you to have a new nose. You know, that's not the point. But there are things you can do depending on your level of trust. And unfortunately, the medical culture is that they just want to check the box. And that's what we're trying to overcome. But it doesn't just fall on your shoulders. If you find a challenge with a particular medical provider or hospital, then reach out to me or to anybody else in this community. Maybe they could use a free training and we'll get them CEUs. I've done trainings for doctors and at the end they go, thank you. No one has ever explained what guardianship really means. I thought it was a blank check, and it's not. So that's something to consider, that medical legal partnership. Yeah.
So I didn't realize you could select which part of their world guardianship would be appropriate. I was under the assumption that guardian is this big umbrella or supported decision-making system. So that was kind of new. You can maybe talk through that a little bit more? Everybody's shaking their head.
Yeah. So I'll restate the question. The idea that guardianship and supported decision-making can coexist and guardianship can be customized. Remember when I said we must always finish the sentence, capacity to do what? Guardianship law changed with a lot of the reforms where we're not asking, do they have capacity or not? We're asking, what don't they have capacity for? And then we're customizing the court order to address only those things. Because if we do too much, that's overreach. And if we do too little, we're not actually helping the person. So now guardianship law asks, when you file a guardianship, have you tried less restrictive alternatives? And you would be able to say, Your Honor, we did a supported decision-making agreement and it's working great for these decisions, but it's not working great for these other ones. Maybe your son or daughter has fetal alcohol syndrome and their decision-making capacity is not helping them be safe. Then maybe you use the doctor's determination coupled with the other documents to right-size your guardianship. The challenge is that doctors love checkboxes. And the old guardianship form, 2 pages, and it was essentially, does your patient need help or not? And doctors really believed by checking the yes box, they were opening up a world of wonderful supports for their patient. They didn't understand that they were taking away possibly their right to vote or their right to go where they want to, or the right to sign a contract. They didn't realize that that was what they were doing. So the new form is much longer and it actually lists all activities of daily living and talks about what your capacity is for those things. Because under the old guardianship, in theory, I could say, I need help doing my laundry. I need the guardian. Or if I broke my arm and couldn't sign a check, that could be enough to get me a guardian because they need to do that for me. It was ridiculously broad. And we've tried to narrow it to what it should be, which is, what do you need help with? What level you need help with? One major thing for existing guardianships is they have financial and healthcare. If you don't have any assets, why do you need financial guardianship? Or if you have a rep payee through Social Security, you don't need a financial guardianship. And that makes people happy because financial guardianships, what we call guardianship of the estate, require a lot of reporting, a lot of sharing your financial records sort of publicly that is an intrusion. So a lot of financial guardianships aren't necessary these days. And with healthcare, like I said, you could do even what's called a special limited guardianship for a very particular situation and leave the rest of the rights reserved. Yes.
I have
This
a
is
question.
After her question, I have a question. This is Kamala.
Okay.
I have a question, and this is just what I've heard. This isn't an argument in any way. I've heard that when you get guardianship and you take away those rights to get married, to vote, I've heard that there's a simple, and I need to just understand if this is true, that you could just go online and get a page printed up and sign it for that person you've taken guardianship. Like the right, they can vote, I sign.
So the question is, if you have an existing guardianship that seems to have taken away someone's rights, can the guardian delegate those rights? No, because now you're under the court's umbrella. And to take or leave things in that space, you need because you've accepted what they call the jurisdiction of the court. The court has now stepped into the situation and said, Susie doesn't, for example, have the capacity to decide to get married. Doesn't mean that mom can sign that away. You go back to the judge and say, we need a new order.
So it's not as simple as going online and printing up a page.
It is not as simple as going online and printing up a page. And that is part of why you want to seriously consider whether you use guardianship, because you've now made it harder to do certain things that under supported decision-making or a power of attorney would be a lot less informed. So guardianship is very formal. Now, when they do these court orders, the judge tells you what you can do, but everything else is reserved. So if the court order doesn't say anything about getting married, the issue is that marriage is a contract. And so we do have people come to the judge and say, can you please allow this marriage to go forward? I had a case where my client was mom. She'd been the guardian of her son for many years. And she had got the guardianship because he had, when he was younger, tried to buy a car. And he tried to buy the car for the first monthly payment. Didn't understand that there were monthly payments after. She drove him to the dealership. She tried to get back the car. This was in the 80s, and said, my son didn't buy this car. He didn't understand. And every day they would drop the car off. It would be back in their driveway the next day. So she went to an attorney, and the attorney said, we'll get him declared incapacitated. We will have a judge say your son can't make these choices, and that will end the contract. So they did that. But 15 years later, her son had a job, her son had an apartment, he was living largely independent, and she still had this guardianship. And the sad part was my client believed that she had to keep him safe. And part of my role as her attorney was helping her walk back from this extreme involvement in his life, because she'd gotten bad advice before, right? And he wanted to get married, and she didn't like the girl, and she wanted to use my service to block it. And maybe she was bad news. Maybe it wasn't gonna be great, but we actually were able to end the guardianship. We had some court oversight for the first year of their marriage because she just really couldn't let go. And then they went their separate ways. And in the end, I think she was relieved to finally have someone tell her, enough, right? You've done everything. You get to graduate to just being the angry mother-in-law. Right? But guess what? This is for every parent, every child, right? It doesn't matter disability or not, watching your child make bad choices is hard. It's so hard. So there was
This
a
is-
question online.
Yeah. So my question is in regards to support shared living provider. I'm my daughter's shared living provider, and you can't be their guardian and be shared living provider. If you do this partial guardianship, like either you do a medical or a financial, are you still disqualified from being their shared living provider?
I will make sure I go slow because this is pretty technical. In some states you can. Nevada has decided that that's a conflict of interest if you are their guardian in any way. Oregon doesn't do it that way, so there are Centers for Medicaid and Medicare Services rules that the state could opt into to allow you to not have to split those. It's something that's an ongoing discussion, but right now, if you are their shared living provider, because the Aging and Disability Services Division doesn't have the staff to monitor and do quality assurance on whether you're exercising your authority appropriately, they don't allow it. And the issue is, for those who don't do shared living, is that if you are the person who's doing the work and the person who's paying for the work or approving that the work got done, that's considered a conflict of interest. Now, when you're their family, why on earth would you try to exploit that? If the state were willing to be a partner in keeping tabs on those accounts or checking those, then you could be their guardian and be their provider. But right now, Nevada isn't set up that way. So usually one parent is the guardian, the other is the provider, or a son or daughter is the guardian, and the other is a provider. And it's a shame because it's hard if you're the only one and you're having to choose. So I would encourage to just keep asking for the change. I've asked for it. I know the judges in Washoe County Guardianship Court have been asking for it. And it's really a funding issue for the state to monitor. But have a look at Oregon if you're curious. If you kind of want to go give public comment or try to argue for why that should be changed, that might be an option. But your core question of, is there any version of a guardianship where I could also be their shared living provider? No, not right now.
Thank you.
Good question. Yes, that's a question.
Part of the decision making then.
So you can be a shared living provider and be their supporter, and we actually built that into the bill. So when we wrote the bill, some people didn't want, like, people who were professionally helping you to be allowed to be your supporters because they felt that was an inherent conflict of interest. But we wrote it so that you can be their provider and be their supporter. The key would be just watching that carefully. For example, the state's staff could even be a supporter. Their attorneys advise them that's not great from a liability perspective, but we built it into the law in case a program ever existed that would help. And the reason is this: a lot of older individuals with disabilities, unfortunately, because they've been secluded in their lives and not really developed the friendships that they would otherwise have, the people in their life are their providers. And so it would be awful to not be able to use supported decision making because 30 years ago, someone decided that you were going to live in a shared, living situation, and these would be the only people you knew. No one's taken advantage of it in that sense, but if you're the family member and the provider or direct client services provider, you legally, under the Supported Decision Making Act, can be both. It's just about, say you're working through an agency, maybe their risk management team doesn't like it for other reasons, but nothing in the supported decision making world says you can't. Has to do with their appetite. Yes.
Could you ask if anybody on Zoom has questions?
Yes, I see there's the people in the chat. Are there any questions, other ones? Yes. Awesome, ask away.
I'm not sure who is supposed to be asking that. Maybe we could address that person individually.
You're fine, we'll pass.
¿Me escuchan? Ok. Si yo me convierto en la tutora parcial de mi hijo que tiene autismo, él pierde sus derechos de respaldo de Medicaid para sus gastos médicos.
That's a great question. The answer is no. Not being guardian or being guardian doesn't affect eligibility for Medicaid at all. The only thing that might happen is when you call Medicaid to ask a question and you're not the guardian, they may ask you for paperwork to show that your son is okay with you talking about his private medical information. And there are ways to do that without a guardianship.
Ok. Muchas gracias por la respuesta.
Well, thank you for asking. It's a really good question because Medicaid can be scary. Go ahead. Hi.
So along the lines of what Maria was asking is, you know, we don't have to have one umbrella at either guardianship or supportive decision-making. So say that we, I guess, then have a document that's been approved by the court where it's been handpicked on this, you know, is this, and what if it, say it's mostly supportive decision-making and a couple of items that are guardianship, would just having that keep us from being able to be the shared living provider?
Interpreter's asking to slow down again. Thank you.
I'll repeat the question. So the question was, even if 10% is guardianship and 90% is supported decision-making, does that still mean the guardian can't also be the shared living provider? And the answer is any guardianship, no matter how small, under Nevada rules, disqualifies you from being a shared living provider. Like I said, that's not fair, and they should look at it more carefully, but their rules are written like the checkbox, and it might be administratively more efficient for them. And I used to work at Aging and Disability. There are great people who work there. I work at purchasing now, so I do a lot of the shared living contracts. And people run into all kinds of challenges about insurance, paperwork. And at the core is someone who loves someone else, who wants to help them, doesn't understand why it's being treated like an inquisition. So you're going to run into those issues, and maybe we can start chipping away at them. But the rule about shared living providers is a rule that comes from Health and Human Services and how their program is organized. And they may not like that people know that it's an option, but they need funding. It's gonna change. Yeah.
There are a lot of us in this room that do know what shared living providers are, but there are some that maybe don't. Would you like to just explain that a little bit?
So the question was, can we explain what a shared living provider is? So there is a framework where you can get compensated or paid for the work you do taking care of someone in your home. It doesn't have to be somebody who you're even related with. There are people who run shared living homes and they don't have that relationship with the people in the home. They provide, you know, there's like a shared kitchen, they have their rooms, The individual might help them with daily activities, getting them to job opportunities, helping with transportation, and they can be paid by the government for their time. And the logic is that if they didn't do that, then the government would have to pay for a more restrictive and more expensive option than being in the community. So under Medicaid, you may have heard of the term the waiver. And the waiver is where the government has said, if it would cost you twice as much to be in an institutional setting, like a more medical setting, than it would be to be at home, why don't we help people stay at home in the community? The problem is that there's a lot of red tape for that setup, because they worry about somebody who would pay themselves for hours that they didn't get, right? They want the guardian to be a different person than, than the other. And you don't have to have a guardianship to have shared, right? You don't have to have a guardianship to have Medicaid. But sometimes when people are trying to sign up for these things, they get told, oh, you're gonna need court papers to sign this form. And it's a shame. It shouldn't be that way. But shared living is a great option to still be in the community, have friends and a neighborhood and all those things. And studies have shown that the greater your independent living, the less depressed you are, right? And the less negative health outcomes you have. In the Down syndrome world, life expectancy went up exponentially when people stopped being institutionalized. And I don't think people in the institutions thought they were doing anything wrong, but imagine if everything you do every day is decided by somebody else. You just wouldn't really feel like you wanted to get up in them. And it applies for everybody. But if you've never heard of shared living and you're realizing, wait, maybe my loved one qualifies, I'm already unpaid, giving all kinds of support to them, and I could get some money to help make our home a nicer space, or, or pay for the fact that I'm not going to work, I'm staying home, then absolutely that's something to explore. So we'll go to the next, we have a few more slides we'll go through. We want to make sure there's time for you to go through a discussion guide. But some of this I've already said, but I will speak slowly. A supported decision-making agreement must be in writing, and it has to be signed by the decider and one or more supporters. So that's where you need at least one, and they have to agree to help, and they have to agree to the guardrails. It has to have two witnesses who are not the supporter or the decider at the meeting when it's signed. There was a lot of talk about making it a notary form, but everything that makes this harder is something that strays from informal decision making. So it just needs to be that there were people there who, if we ask them later, did Susie really agree to this? They can say, yeah, I was there. And the agreement just has to say what you can do. And there are a lot of great forms and guides out there. People wanted a form in the statute, and we didn't want that because it's going to become the checkbox. We're fighting the checkbox. We want people to customize it, but I understand that it can be overwhelming to say, how do I write this? We have links at the end to a great website that has sample forms. So you won't have to go it alone, but the law only requires these ingredients. Everything else is frosting. So next. This graphic is something we've already talked about. Remembering the bundle of sticks. In supported decision-making, you guys are partners. These two stick figures are interacting with schools and medical and banks together, side by side. Whereas in power of attorney and guardianship, often the providers of these services don't get to hear how the individual at the center of it really feels. And that can perpetuate that culture of, are you the guardian or not, right? We want, and actually, the situation on the right isn't true, right? We want even powers of attorney and guardianship to be side by side, but society treats it like, oh, your power of attorney is here, you don't need to be here. we'll have a discussion without you in the room, right? So just think about that when you're considering the options. Next. So a note about powers of attorney. A power of attorney is a document where the principal, like a decider, gives another person, their agent, the power to speak for them. Like when you hire a real estate agent, they're being given some power to list your house for sale, right? You didn't give them your house, right? You are asking for their help. The agent should not agree to things the principal does not want, but they can make decisions sometimes if the principal is unconscious or not able to communicate. That's where supported decision-making is great until somebody's in a coma, right? And it's great to also have these tools available for when you need those decisions to be made. There is a form for intellectual disabilities that's in plain English. It's free. Nobody should ever make you pay for it. We can share copies, though there are resources with them. But you've heard about powers of attorney, so I wanted to mention it. A lot of doctors believe if you're the power of attorney, we don't need the other person in the room. It's not legally true, but plenty of them will honor it that way. So next slide. So guardianship, we've talked a lot about it, is where a judge says someone can't make their own decisions and there are no other options to help them, right? So there's nothing less restrictive and they can't make or communicate the decisions. It doesn't say they're making bad decisions, that they can't make the decision at home. And the doctor has to tell the court what the person can't and can't make decisions about. The guardian, if approved, gets to make a lot of choices, but the person at the center of the guardianship, called the protected person, gets a free attorney in Nevada to represent them in their case and tell the court what they really want. This is big because usually when someone is said to have no capacity, they're also determined to not have the ability to have an attorney relationship. But Nevada law says, no, you get and keep this attorney so you can have that help. And the guardian can't just make whatever decisions. They have to be in the best interest of the protected person. So next slide. A good guardian should be like a good supporter or agent. They should hear what's important to you or the decider and care about it. They can make decisions that you don't agree with, so you should always try other options first. Guardians sometimes try to make decisions they aren't allowed to make, like where someone goes, what they do for fun, who they talk to. So we created the Protected Persons Bill of Rights to remind them of their rights, and they have to be informed. So if you have a friend or a family member in a guardianship and it is working for them, awesome. A lot of guardianships are really supported decision-making agreements just with a judge watching. But the next slide is the Protected Persons Bill of Rights. And this is in your materials. I won't read all of them, but each one, I put it in gray and now I see that it's kind of hard to see. But for example, the right to due consideration of preferences. So you can't be railroaded in the guardianship. The right for respect and fairness. So the right to be treated nicely. So we might sit here and say, why did we have to put this on the books? Unfortunately, there were some people who believed that being a guardian really meant that they controlled them. It's not true, and there's actually financial penalties, $5,000 penalty for each violation of these rights by a guardian to try to get people's attention. Don't just tell them they can't go to the movies or have a friend because you didn't get to decide that. Don't say that nobody can call them and figure what's going on. I had the cases that I mentioned with that bad guardian. Families called me after we got rid of her, and they said she told me that I would never see my dad again if I told anyone what she was doing, right? Then nobody should have that. It's a shame, and that's where the Protected Persons Bill of Rights came. So next slide. As we've been saying, options can coexist. Some people use supported decision-making for some things and a guardianship for others. Some people use it for different phases in their life. So someone who has just been diagnosed with dementia might use supported decision-making while they still can communicate decisions. And then if they decline, they switch. So it's great even for seniors that had that question. Cultural change takes time. You will find people who resist inclusive models of disability because of their own fears and concerns. And it's okay to get help reaching out to those people to explain it to them. It's not all on you to have to explain why your loved one should be included. So next slide. We got some questions in advance of today. One question was, do supported decision-making agreements hold up in court? And my answer that I wrote was absolutely. In fact, guardianship courts will ask you, did you try this first? They are also valid in other states. So if it's true in Nevada and you were visiting San Diego, they need to honor something that's valid in Nevada. But before we started, I got the additional question of, can a supported decision-making agreement mean that a contract that someone signs that is good for them is invalid? No, because remember, they have capacity, unless the judge says they don't. So that person could still make decisions that aren't good for them, and the supported decision-making agreement wouldn't be able to get rid of that contract, but their supporter could help them fight the contract, right? But that agreement alone isn't going to mean that they couldn't decide it. Is there a special form I should use? As I mentioned, there's helpful forms. You're welcome to use them, but it just needs to be in writing. Have the two witnesses, say what you can and can't do, and have everybody's signature. That's all it means. Doesn't have to be too complicated. And do you need to file your agreement anywhere and make it valid? No, it doesn't get submitted to the government, but you could make sure that it's on file at school. You could make sure it's on file with the doctor if you want to. But you may have heard of the guardianship lockbox. The Nevada Secretary of State has a lockbox where you can file a guardianship nomination form. So what you may want to do, if you're interested, is if they know that they would, if something bad happened, they would like you to be their guardian, they could fill it out, file it with the Secretary of State. And if somebody comes along in 10 years and tries to swoop in and file a guardianship, the judge has to check that file and see if they've picked somebody already. So that's what that lockbox is, that you don't file your supported decision making anywhere. And next slide.
Have a couple of questions.
Yeah, and we'll do that for sure. So I want to make sure there's time for that. So go ahead.
We've got two. One is coming from Vegas, and then I have just some clarification on that first for your common questions. I don't have it in front of me, but it seems there's specific language in the statutes that say, and it backs up what you said about if they sign a contract, that it's still valid, even though there's that supported decision-making agreement. If that were to go to a court, have you seen that? Does the court offer leniency when they have a mild intellectual disability, even though they still can make their own decisions? I mean, is that something we should really be worried about? And then the other question is from Vegas, and they just want to know, at what age should parents start doing all the guardianship paperwork?
I will start with the first question, which was, is it something you should be worried about that someone with an intellectual disability might sign a bad contract? The contract law doesn't stop existing because the person who signed it has a disability. There are contract law principles about being fair, being honest about the deal. So no matter the capacity of the person signing, there are ways you could attack a contract that was so one-sided, right? Something where you're paying way more for something or taking advantage of somebody. So there would be ways to challenge it, but they would have the right to sign an agreement if you're trying to overturn that agreement, you can argue that they didn't understand it, but you don't need a guardianship to make that argument. So, especially if the parties have differences in power. So your question is, should we be worried? I would encourage people to practice the safety skill of, if someone puts something in front of you and says, sign, what should you do? Maybe ask for more time, maybe ask to take it home. Like, you could teach the skills around contracts so that they ask for help. But every single one of us has clicked through a contract on a website that we have not read, that probably gave away something. So bad contracts are kind of a part of life, and sometimes courts will throw them away because they're so unfair. So that's something to think about. And for the other question, from Las Vegas, remind me what the question was. I was writing it down.
It's at what age should they start the guardianship paperwork?
So the law allows you to file as early as about 6 months before someone's 18th birthday, but they can't have a hearing or make a decision on it until someone is actually 18. But I would encourage that instead of filling out guardianship paperwork specifically, start having the conversations as early as you like about what the future looks like. Washoe County has their own supported decision-making agreement template that you could use. Clark County might have that as well. Legal Aid has free forms. So maybe don't think of it as a guardianship discussion. Think of it as just a rights discussion. And if you determine that there are things that need a guardianship, absolutely, there are free forms online and you can start filling them out and file them for, with the court for free. But be prepared, the judge is going to ask, what else did you try and how did it go? So there's no harm in, you don't need on their birthday to have a guardianship. Maybe give it a test run and see how it works. And then you could stand in front of the judge and say, we tried it for a couple months and it just really wasn't a good fit and we couldn't cover this situation. And you'll have a smoother experience than if you just go straight to guardianship, because the judges have all been trained to really question you. And it's not a nice feeling in a court to have your decisions as a parent questioned. So just show your work, right? We know you're thinking about these things and trying, and it's worth it to have the paperwork to say, here's our supported decision-making agreement, and we tried it out and we ran into a roadblock. So, but no harm in talking about it or getting advice as soon as you would like. So, yes.
Question. When I think somebody's asking a question there, but I have a question in Vegas when they get done.
Okay, yes, one here and then Vegas, and then I know we may want to just talk a little about the form, and then if we have time, I can stay, answer questions. Go ahead.
Okay, so if we decided to go guardianship and our husband is the guardian or the caregiver, would we still be able to be a shared living provider?
The question was, if you have spouses and one is guardian and one is the caregiver, could you still be a shared living provider? The one who's not the guardian can be the shared living provider. Your marriage doesn't, affect that, because remember, you can't give away your decision with guardian to someone. So there's no risk.
Okay, so are there any other services we would be omitted for? I don't want to become a guardian, but I'm just asking to see the flip side.
Are there any other services where the guardianship is a downside to getting those services? I haven't run across them. Usually the court hearings that I've been in are one spouse is giving up their guardianship so they can go become a provider, and it was the first they've heard of it. If people run into them, they haven't reached out to me, but that's the only one I'm aware of, is the conflict of interest. You can't be the payer and the charger at the same time in the event.
But we wouldn't be omitted from being a hotel.
You would not be omitted from being a host home. Be aware that if you are a guardian of more than 2 people to whom you are not related, you're a private professional guardian and you have to be bonded. So that's the one thing where, say you were running a host home and your child was in it, but then you also took care of other people, you might need to become a private professional guardian to take care of those people. Which is not, it's not terrible, but a lot of people don't realize it, but it's, they want to regulate people who are making a living off of being. And
Okay.
there's a question in Vegas.
Yeah, I want to preface it with a message to our family navigator in Vegas to make sure they send this person the information from our last one of these that had to do with and third party special needs trust, because I think that is more applicable to this. But their question is there a legal paperwork to protect a minor if something happens to the parents?
So the question of helping a minor if something happens to their parents, there's an informal temporary 6-month guardianship form they can fill out, doesn't have to go to a court. It just says that this, so say you were going overseas and you weren't going to be here to take it to the doctor, you can for 6 months give anybody that authority. There are some caveats if you also have a custody agreement, right? Where you have 2 parents who are divorced and you can't give people authority you don't have, so both parents would need to sign it or that sort of thing. But definitely, I can also send some resources to email. If you take the person's information down, we can connect them with some samples. And I know
Thank you.
Marcia had a slide she wanted to put up at the end, but we've got the brainstorming guide, which is super cool. And one note about the brainstorming guide, it mentions something called conservatorship. In California, conservatorship is a financial guardianship. In Nevada, we call both the healthcare and the financial ones guardianship. But if you see the word conservatorship, it's referred here on this form. Just think of it as guardianship because that's what we need. Go ahead.
Thank you, Homa. That was amazing. Does anybody have any questions? But when Homa's here, we'd love for you to take advantage of that.
Or email.
Or email.
Yeah.
Okay.
These resources as the layout.
Which resource has the layout for supported decision-making agreement?
The first one has some great tools you can download. And I linked to the Access to Justice Commission because I know that statewide, we're talking to Vegas too, but your local legal aid has forms too. So that's dmnevada.org is free.
And I have a form I'm gonna send out in the follow-up email. Yep. As like the last, yes, Mr. Sure, I'll send an email to everybody.
Or send it to them at FNN so they know the question got asked.
Okay, I'll be sending Homa's email to everybody in the follow-up email. And as like last time, the speaker is so engaging that we're running a little bit behind. So if anybody has to run out, feel free, we will not take offense. We'd really like, this brainstorming guide is great for thinking through, will guardianship be best for your loved one or supported decision-making? So questions like, if you're planning for the future, you know, this tool can help you think about ways to learn and practice supported decision-making. If you're considering guardianship or so conservatorship, supported decision-making can sometimes be formalized into arrangements that will prevent situations that you're fearful of. So on the second page, the first page just really kind of goes through what this brainstorming guide is about. But when we leave this room, we never have time to go back and like really think through some things because we, you know, our kids are having seizures or, you know, we just didn't even get to shower. We'd really like to shower that night. So it gives us a minute here to spend 5 or 10 minutes really thinking through what's best for your loved one. So the first question on the second page is, how does the person with a disability manage his money? So thinking through, if no one ever talks about money with the person with a disability and they do whatever they want, that's not supported decision making. So it's really coming side by side with the individual to educate them on what do we do with money? How does it work, right? What is a debit card? What if someone asks you for money? Do you give them money? So this thinks through, and you're welcome to do a little brainstorming yourself. We'll just have a quiet minute. how we work together to help the person with the disability or member manage his or her money. And these things will take a minute, then you can think through how you might do that with your loved one. And if you think it would be possible for them to manage this themselves or with a little bit of support, or is it something that we need to do for them, which would be more in terms of guardianship.
Quick question.
Yeah.
What if you want them to have the capacity to make choices with their money, but they don't have the ability to make the right choices? I mean, where do you go?
Yep.
What do you do?
Very good question. The question was, what if you would love for your loved one to be able to make these financial decisions, but maybe they don't exactly have the capacity to do so? So what do you do? Homa, would you like to speak to that?
That's okay. That tool in that moment is not for you. It doesn't mean you're not open to it if they develop that skill. There's plenty of 18-year-olds who really shouldn't be managing money. And actually, people will prey on that, right? College campuses, they'll sign people up for credit cards. A lot of young people end up in credit card debt out the gate because they didn't know or didn't make a good decision. So you could also look at this as a moment in time. It's a snapshot. They could learn more skills, they could, or maybe they never become interested or have that ability. But maybe it's a good idea that you help them with that, but sit down with them when you do their banking. And so that they can see what you're doing, that maybe they're not making the decisions, but keep it always in their mind that you believe that they have the right to do this, but you're just helping them. So it's kind of a messaging thing, so that maybe when they're older, they do. And really, the apps that we have now for tracking money and stuff like that, maybe it's a great idea to get them one of those credit cards that, you know, that can be monitored. And Eric is going to be doing a presentation on able accounts coming up, so there'll be some more on money management as well, but it's okay if it isn't the right fit.
So if you were in her scenario, would you do supported decision-making overall with power of attorney over financial?
You could do that. So you could have a supported decision-making agreement first that says they would like your help doing a power of attorney. And then you would meet, you know, with an attorney, a free attorney, or work on the form, and they could give you the ability to manage their money. But you would make sure they knew that if you ever want to stop this, we can stop this, right? That the message is not, I don't think you can do this, it's just.
So she wouldn't have to get guardianship.
She would not have to get guardianship if they were consenting to you helping with money. They didn't have the capacity to consent, then you need to go to
That, okay, that was my question, because what if they don't have that?
Yes. And the doctor, when they fill out that 7-page form, is gonna check the box saying they need financial.
One second, Matt. Marcia?
We have a question online from one of our Spanish speakers, so if you give me just a second, I'm going to switch to the Spanish.
Ok, mi pregunta es, si mi hijo tiene autismo y no tiene la decisión para determinar si él quiere que yo sea su, sí, que yo tenga su tutela, ¿qué tengo que hacer en este caso?
Changing the channel cut us off.
I'm gonna switch over to the Spanish channel.
Not very good Denny's question, but I took French, sorry. Wrong language.
Julia.
Oh, here. Go ahead, Julia, you're good.
Lost her.
Uh-oh, she was good.
Maybe go back to English. Make sure.
Can you go back to the English channel?
Okay. Julie, could you try again? Yes, now. So the question is that her son has autism, and what if he can't make these decisions? Guardianship might be the best option for you right now, and that's okay. And the doctor's note in the form packet will help the judge know that
Ok,
just not.
pero quería saber si en la decisión de que yo tenga el tutelaje sobre él tiene que decidir eso o no.
Your son will get a free attorney who will talk to him and see if he's okay with you being guardian. If he says no, the attorney will tell the judge. But that's not the only decision. The judge will look at everything, including his medical, to see if he understands what he's doing.
You're good. You can ask me this.
Ok,
This is Kamala. I just want to say I'm going to
Okay.
jump off here in about a minute. So if anybody in the chat has a question, maybe tag someone.
le voy a volver a preguntar.
Yeah. Tag someone so they see it
Le
because
voy
I'm
a
going to
preguntar a
exit.
usted y después cuando ella termine usted le pregunta.
And if we could let
mi pre-
Soraya know to mute
Ok,
herself.
le voy a escribir porque creo que es para que pueda atender el chat.
Marcia, can you get off the Spanish?
I don't know why,
So
I
we can-
think she jumped
No,
on
she's-
it.
Oh, she jumped on English.
Should manage it.
Okay,
So
Sí,
if there are more questions, reach out to FNN, they can connect you with me. I can't give you specific legal advice, but I can connect you with resources, with people who can help. They may have answers too, but you're not alone. And it's okay to be totally overwhelmed, but we're all here to help. Thank you.
And we'll get your email.
Yeah.
yep,
Thank you.
and I'm just gonna let you think through these other things, financial, healthcare, social, in your own time and space, unless there's a specific question to any one of them. Love to show you this video on supported decision-making that the Nevada Center for Excellence in Disabilities had put together during the time when you.
The Governor's Council
Okay.
on Developmental Disabilities gave a grant to a great project to increase awareness about supported decision making.
There's a series of videos, but we're going to show you one. Erin, give me just a second.
Yeah.
And did you not have questions?
And while Marcia's scrolling, a question here was, do you need a doctor's note for supported decision making? No, because once somebody is 18, they are able to sign an agreement like that. There's no need for the doctor to fill anything out.
I know, I was gonna say.
Do you need a doctor's note for guardianship?
Here's a little video.
Tyler needs a lot of support, but wants to make his own decisions about his life. He has many people helping him, including his mother, Tony, who is his primary supporter.
Tyler has multiple disabilities. I think there's 32. He's an overachiever on so many things. He's now 19 years old. Well, his father left when, like, over 10 years ago, because, having a child that's severely disabled is difficult, and it does interfere with your life and travels and things. So his father thought that when he turned 18, he would be free and clear. But what happened is there's actually a law in Nevada that says if a child is disabled, you pay child support for life. Tyler's father did not want to pay child support any longer, and so he wanted to try to put Tyler in a home, but because of Tyler's medical conditions, there really isn't a group home.
Oh, you can't? Okay.
They'll hear it.
Tyler needs a lot of support, but wants to make his own decisions about his life. He has many people helping him, including his mother, Tony, who is his primary supporter.
Tyler has multiple disabilities. I think there's 32. He's an overachiever on so many things. And he's now 19 years old. Well, his father left when, like, over 10 years ago, because, you know, having a child that's severely disabled is difficult, and it does interfere with your life and travels and things. So his father thought that when he turned 18, he would be free and clear. But what happened is there's actually a law in Nevada that says if a child is disabled, you pay child support for life. Tyler's father did not want to pay child support any longer, and so he wanted to try to put Tyler in a home, but because of Tyler's medical conditions, there really isn't a group home that Tyler would be able to go to, and Tyler does so much better here. Taking care of Tyler is very complex, and most group homes would not be able to take care of him. The only medical facility that could take him is in Carson City, and it's more for kids that are in a comatose state or severely disabled. So his father tried to put him away, but because this law came out of supported decision making, it's the only thing that saved Tyler. Now Tyler would have to agree to be put away. So this law literally saved Tyler and us from him going away and being put away. I don't have family, so it's not like I could have family, but there were friends that they also had children with VNS or severe epilepsy or serious food allergies or autism. And so they're the ones that I reached out to form a group that would help me and Tyler making some of the decisions to make sure that I wasn't just using my mommy's heart, that it was logical, that I had the power of attorneys filled out so that I could do educational, medical, financial decision makings for him. And it's just fabulous. I don't have problems with when we're emergency hospitals or San Francisco hospitals, or they've all taken the paperwork. So they all understand that Tyler is his own guardian.
Does anybody have any questions about that? Okay. Thank you all so much for coming. Thank you, Homa. I'll be sending out a follow-up email with a ton of resources. If you have any questions, reach out to me. If a lot of you reach out, I'll put together frequently asked questions and send it to all of you. Thank you. Thank you, everybody. Yeah, I don't